Oh my god, could you all not hear me the whole time? I literally can't. I'm not cut out for this, for real. Oh my gosh, what on earth? I told you I'm not a content creator at all. Bless you all for sitting here this long. My god. I don't even remember what I said at this point. I think one thing I said was, if something didn't go wrong, then it probably wouldn't be mine. But, like, I mean, and here this whole time, I'm like, "Why is the screen just like why does it just say my name? Where's everything?" And there's, like, multiple people back here. I'm like, "Shit, I think I shared the wrong link." Like, I don't know what I'm doing. Oh, Lord have mercy. Some people are saying no sound. This is ridiculous. Alibis always sound so delightful. Alright, I'm gonna try to share this. Mm, mm, mm. Alibi. Alright. Could you hear me say alibi? Fuck it. A little pro tip would be, like, to just not do this anymore, but oh, good. Okay. Alright, let's talk about this alibi. So, here's the thing, is that I heard repeatedly all over the place that if he had an alibi, he would have already given it up. Um, that if it was a solid alibi, that he would have no problem giving it up. So I was curious and I started looking into everything, and that's like the complete opposite of the case. Um, so I put together like a whole thing, and I'll once I figure out where we're gonna stay this whole time, I'll put a bunch of links in so that you all can go look yourselves. But I it's really it's not that simple. And also then today, here just a little bit ago, they put out a new filing, and the state is giving the defense until July 24th. They think that that's a reasonable time to be able to extend it to give over his alibi. So that's good, right? Because I mean, that seems reasonable. Surely he would know, the prosecutor, how what would need to go into establishing an alibi, because unlike what some people are trying to make it seem like it is, you can't just say, "Well, I was with so and so," or "I was on a run by myself," or "I was asleep. Duh, it was 4 o'clock in the morning." Like, at this point, you've gotta have proof of that. And I also think that what a lot of us aren't realizing is that you can't just say your alibi, and they're gonna look into it, and then if it checks out, they're gonna let you go. It's still gonna go to trial. We talked about this briefly, the other day. It's still gonna go to trial, and then it's gonna be up to the jury still if they feel that you've established that alibi, and created reasonable doubt. So just because you have one doesn't mean that the police are gonna say, "Okay," or the prosecutor's gonna say, "Okay, I'm gonna have, you know, my best investigators look into this, and if it checks out, you can leave." It doesn't work that way, and it won't work that way. And I think that it's important that we do understand how it actually works, since experts seem to not wanna care to actually tell us how it works. I put together a bunch of stuff that maybe might give us a little bit of better insight as to how it does work, and I'm sorry that you're gonna have to watch the same, like, couple minutes over, but maybe we needed to hear something that maybe we missed the first time. So I'm just gonna share the whole thing. I hope y'all don't see anything that you shouldn't. Hmm. Alibis always sound so delightfully healthy, but they crack up dreadfully easily. Whatever the truth about his defense, Dave Ansey, it seemed, had total faith in it. As for me, I'm not sure that I like cast iron alibis. They're the sort that sink quickest to the bottom of the sea. No, no, no. The New Jersey Supreme Court had said that I gotta figure out how to play this. What a clusterfuck. Thank you, JB. But it was playing, but it wasn't, like, big, it wasn't the whole thing, it was, like was it? Was it perfect? Oh, shit. Alright. I guess I'll know who's, like, actually here for the information, I reckon. Let's just share the whole damn screen. Share system audio. Right? Share system audio? Yeah, fuck it, let's just okay. So you should see the whole thing, okay. Alright. I'm gonna make it big. Alibis always sound so delightfully healthy, but they crack up dreadfully easily. Whatever the truth about his defense, Dave Ansey, it seemed, had total faith in it. As for me, I'm not sure that I like cast iron alibis. They're the sort that sink quickest to the bottom of the sea. The New Jersey Supreme Court had said that few defenses have greater potential for creating reasonable doubt as to a defendant's guilt in the minds of the jurors than an alibi. But is alibi a powerful defense or a risky gambit with a high likelihood of backfiring? Courts and prosecutors contend that alibis are easy to manufacture and effective defenses. Alibi, some courts suggest, has long been considered as one of the main avenues of escape of the guilty. Other courts refer to it as a hip pocket defense because of the ease with which it can be manufactured for introduction in the final hours of the trial. Concerns about easy fabrication underlie notice of alibi rules found in many jurisdictions. Defense attorneys, on the other hand, frequently decline to offer alibi witnesses out of concerns that the jury will reject the defense after the prosecutor's clever cross-examination and summation, leading to the defendant's conviction. Appellate dockets frequently contain post-conviction cases arguing that trial counsel was ineffective for not investigating or not presenting alibi witnesses. If I mute my mic, nothing happens. Oh, wait, what if I remove me from Alibis always sound so delightfully healthy, but they crack up dreadfully easily. Everything about his defense, Dave Ansey, it seemed, had total faith in it. As for me, I'm not sure that I like cast iron alibis. They're the sort that sink quickest to the bottom of the sea. The New Jersey Supreme Court had said that few defenses have greater potential. I'm going to cry. It wasn't echoing, though, was it? Oh, what a fucking nightmare. I bet you I can't get a hold of any live person at YouTube either. So I think I figured it out. If I remove myself from the stream and then I do it, you can hear it. But the problem was my Walmart internet kicked me out, I think. All right, I'm gonna kick myself out and then I'm gonna play it. It's just not gonna be real big. And we'll see if we can hear it. Fine at the very end. Yeah, that's what I'm thinking. I think once I removed myself, it was fine. All right. I'm gonna remove myself so y'all can hear it. Hold on. Presenting alibi witnesses. These claims are rarely successful. My belief about alibis is that unless they're solid, they can get you into trouble. It's the last thing the jury hears if you have a good prosecutor who's a good cross examiner and can try to kind of attack either a family member who's an alibi witness or some other vulnerability to the alibi. To me, it pulls attention away from the weaknesses in the state's case, and it kind of develops jurors' focus on the weaknesses in the alibi. So, it's just been my practice to shy away from alibis unless they're solid, and I had some concerns about the alibi in this case. Outing v. Commissioner, where trial counsel testified that she had ultimately concluded, on the basis of her experience as a trial attorney, that the presentation of an incomplete alibi defense, bolstered only by friends and relatives of the accused, often undermines the defendant's defense in a murder trial. Commentators warned defense counsel to exercise extreme caution in choosing alibi witnesses and take pains to ensure that the alibi witness's testimony is consistent with other defense witnesses. There is nothing as dangerous as a poorly investigated alibi. An attorney who is not thoroughly prepared does a disservice to his client and runs the risk of having his client convicted even when the prosecution's case is weak. So who was right? Is an alibi defense the key to the jailhouse door or a millstone? The DNA exoneration cases suggest the latter. In about 2/3, 68% of the DNA exoneration cases, the innocent defendants offered an alibi which was not believed by law enforcement. Worse, weak alibis were used by prosecutors as incriminating evidence at trial. Fact finders, it seems, underbelieve alibi witnesses. Defense counsel's concerns seem validated, and court's fears seem overstated. Yes, an alibi can be fabricated, but so can almost all other testimony. Deciding whether an alibi witness is accurate and truthful is hard. It is easy for a suspect to make a good faith error about where he was when first confronted by police, and easy for potential alibi witnesses to make good faith errors about the details of what was for them an everyday event. Does defense counsel then abandon alibis unless they are complete and unequivocal, based on strangers and supported by physical evidence? The question falls largely on defense counsel because alibi is a reaction to the prosecution. Defense counsel investigates alibi witnesses and looks for confirming evidence. Counsel decides whether to offer an alibi defense, giving appropriate notice, and chooses what witnesses to present and how. Investigators and prosecutors are largely reactive. They follow up on information provided by the defendant and challenge the defense witnesses at trial. Insisting on only offering an alibi supported by physical evidence would mean very few alibis would be offered. Alibis supported by strong physical evidence are rare. Only 14% of alibis offered in a survey of American and Canadian cases were supported by physical evidence, but this may be changing. Cell phone location history, apps, and call records may document a witness or defendant's location at key times. Admittedly, these locate the device, not who's holding it, but it may be persuasive corroboration, even if not absolute. Smart speakers and assistants that capture voices at critical times would be hard to fabricate. Insisting on only offering an alibi supported by disinterested witnesses ignores the risk that the witnesses who are most likely to be believed are also the most likely to forget having seen the defendant. So, what can defense counsel do? Basic research about perception, memory, and good faith errors should be familiar to attorneys and judges from eyewitness identification research and case law. There is also more specific research available on the psychology of alibis. Understanding what one can realistically ask of alibi witnesses and communicating that research to fact finders may lead to a more accurate assessment of alibi defenses and a decrease in convictions of innocent defendants. Where were you that night? The suspect and the initial questioning. My heart started pounding. I had gotten my weekends confused, which meant the alibi I gave to the police was not going to check out at all. An innocent suspect may first learn that he or she needs an alibi when first questioned by police. Questioning may occur soon after the crime when the suspect's memory of where he or she was should be fresh, but it may also occur days, weeks, or months later. The innocent suspect's memory of his or her whereabouts on a past date and time that had no significance until that moment may be wrong, but a good faith mistake may be interpreted as a deliberate lie. The Reed method cautions that where a suspect has an alibi, it is imperative that the alibi be checked, if at all possible, before the interrogation begins. If the alibi is defective, it will help the questioner. If not, it may actually establish the innocence of the suspect despite other circumstances that may point to his guilt. The manual suggests open ended questions to elicit an alibi, like, please tell me everything you did from noon on Friday until you went to bed. The manual suggests that information that is volunteered during a response to an open question, for example, a subject's alibi, will probably all be truthful, although perhaps incomplete, and then gives an example of a truthful answer implying an alibi but not actually committing to it. The manual suggests show gaps in the witness's story to provide details that could be tested. To test an alibi, the manual suggests asking the witness about a fictional event like a car accident that supposedly happened at the time and place mentioned to see if the suspect will believe the false event is true and add it to his story. The author assumes that the suspect has a clear memory of the evening and there would be no delay in saying that the event didn't happen, and/or asking the witness for a detailed description of his activities and then to recount the alibi in reverse chronological order. A person who has related a truthful account will have little difficulty doing this because their memories are based on factual occurrences. In practice, observers have noted that if a suspect offers an alibi, the interrogator will attack it as inconsistent, contradicted by all of the case evidence, implausible, and or simply impossible, even if none of those assertions are true. Innocent suspects are more likely to waive their Miranda rights and talk to investigators. They believe, wrongly, that their innocence will be obvious to the investigators. This same illusory aura of innocence may affect alibi witnesses who expect that the truth of their testimony will be obvious to investigators and may be surprised when it's not. An innocent suspect may have no experience with a serious felony investigation and is likely to be unfamiliar with techniques used by police to obtain admissions and confessions. This may make the suspect more anxious to offer an alibi without taking the time to verify it. Cotton, an innocent suspect arrested a few days after Jennifer Thompson was sexually assaulted, confused his weekends and gave police the wrong information about where he was. This is not unusual. Innocent suspects may not accurately recall where they were in the past. In one study, participants were asked to report their whereabouts on 4 particular times in the past, then given 48 hours to return with evidence of their whereabouts. In this low stress, low stakes test, over one third, 36.4%, were wrong about where they had been. If the suspect in the high stress, high stakes interrogation room setting provides wrong information to law enforcement, officers may see this as a deliberate lie and as evidence of guilt. Cotton, like other witnesses, may have relied on a schema to generate his alibis. He recalled what he habitually did at that time on a weekend, rather than recalling specifically what he did on that particular day. If he in fact did what he usually did, the alibi would be reliable. If he did something different and had forgotten that he had deviated from his routine, then the alibi would be inaccurate. When police are unable to verify it, the suspect looks guilty. As noted above, acquaintances and strangers may not recall interacting with the defendant. If the defendant overconfidently assumes that the witness will do so, then he or she may suggest alibi witnesses who don't recall them when contacted by an investigator. If the alibi witness fails to remember the defendant when questioned, then the investigator may assume that the defendant lied to them and is guilty. The consequences of good faith mistakes are serious. Once a defendant makes a mistake, it may be near impossible for them to convince anyone of their innocence. The one exception seems to be if the defendant lies, then provides a salacious alibi. Changes, even changes that genuinely strengthen the alibi, tend to weaken how fact finders perceive it. Most people have trouble accurately recalling where they were in the past. In Newcamp's study of over 800 volunteers drawn from the community, asked about their whereabouts no more than a week earlier, 90% of subjects reported that they could support their alibi with at least one witness. 65% of those could provide a motivated, familiar person, and 16% could provide an acquaintance or stranger. About 25% could provide an item of physical evidence, typically a receipt. Only 7% believed that they could find video recordings to support their claim. Alibis were weakest during the times when a person was most likely to be at home with friends or at a movie, and strongest when the person was at work or in class. This study supports the general proposition the majority of a person's time, especially at night, on weekends, and during the holidays, is spent with family and friends, the weakest alibi witnesses. In State v. Dixon, the defendant first learned he was a suspect in a murder when he was arrested 18 months after it occurred. His mother and aunt repeatedly told police that he was with them at a sports bar on the night of the murder and asked them to contact the bar to see if it still had a recording to prove Dixon's alibi. Police did not contact the bar, which had a fire 6 months after the New Jersey Supreme Court had said that the Connecticut Supreme Court noted that neither of the alibi witnesses testified unequivocally that the defendant had been in the sports bar with his family at 9:30 p.m. on January 9th, or a risky 2010, when the crime occurred. Moreover, to the extent that the testimony of the defendant's mother and aunt would support that conclusion, both witnesses had a clear motive to attempt to convince the jury that the defendant was in the bar at that time. What about strangers? Other courts would the bartender or wait staff have remembered serving Dixon? What about strangers? In State v. Dixon, the defendant first learned he was. In State v. Dixon, the defendant first learned he was a suspect in a murder when he was arrested 18 months after it occurred. His mother and aunt repeatedly told police that he was with them at a sports bar on the night of the murder and asked them to contact the bar to see if it still had a recording to prove Dixon's alibi. Police did not contact the bar, which had a fire 6 months after Dixon's arrest. The Connecticut Supreme Court noted that neither of the alibi witnesses testified unequivocally that the defendant had been in the sports bar with his family at 9:30 p.m. on January 9th, 2010, when the crime occurred. Moreover, to the extent that the testimony of the defendant's mother and aunt would support that conclusion, both witnesses had a clear motive to attempt to convince the jury that the defendant was in the bar at that time. What about strangers? Would the bartender or wait staff have remembered serving Dixon if asked a year and a half later? Unlikely. Unlike an eyewitness to a crime, an alibi witness has no reason to realize when they interact with the defendant that they will be asked to recall him or her later. The alibi witness may have interacted with dozens of people during that critical time and may not recall which customers were there at that time. What about supporting physical evidence? Suspects provide leads or references to physical alibi evidence in less than a quarter of criminal cases. In Dixon, the defendant's family believed that physical alibi evidence existed, but police did not try to obtain it before it was lost in a fire at the bar. In a survey of police officers, Less than half, 49.2%, said that a thorough investigation of an alibi is always conducted before an arrest warrant is prepared or the defendant arrested. 38.1% said it is often investigated. 7.9% said it is sometimes investigated. And 4.8% said it is rarely or never investigated before the warrant is prepared or the defendant arrested. Telling the police about physical alibi evidence does not mean that it will be pursued. If the police fail to follow up on alibi information, the defendant could combine an alibi defense with a claim of an investigative failure or omission, arguing that a jury could find reasonable doubt if jurors conclude that the investigation was careless, incomplete, or so focused on the defendant that it ignored leads that may have suggested other culprits. This may be especially important to counter jurors' inherent belief that if a case makes it to trial, then there is a reason not to trust an alibi witness. If police had believed the alibi, the case would not have progressed to trial. Police and prosecutor questioning of an alibi witness. What happens when a suspect provides alibi witnesses to the police or prosecution? One survey of 73 prosecutors found that all but one took advantage of notice of alibi rules to make a pretrial investigation of alibi witnesses. Epstein theorized that pretrial investigations would lead to dismissal if the alibi proved true. 19% reported no cases dismissed after investigation. This includes a few respondents who said that they would not dismiss the case even if they thought the alibi might be true because credibility was for the jury. Over half, 58%, reported a few dismissals. 15% reported dismissals in half their cases, and 8% said there were many dismissals. Epstein concluded that the fact that comparatively few cases are dismissed as a result of pretrial investigation is entirely consistent with our notion of alibis. They are usually false. There is another possibility, perhaps unknown to Epstein in 1964, tunnel vision and investigative bias. If the police have arrested the suspect, they have already formed a conclusion that he or she is guilty. When police form a hunch that a suspect is guilty, they may then, without realizing it, discount any evidence that does not jive with their prior belief in the suspect's guilt. Once prosecutors have filed charges and begun to prepare their case, they have likewise concluded that the defendant is guilty. The prosecutorial role inevitably fosters tunnel vision. Ethical prosecutors feel a pressure to push hard to obtain convictions because only a conviction serves the interest of justice. Similar confirmation bias issues may affect judges considering the effect of alibi witnesses on the strength of the prosecution's case on appeal and whether trial counsel was ineffective for not pursuing or offering alibi witnesses in a habeas case. If the police or prosecutor are convinced that the defendant is guilty, then the alibi witness must be either liars or wrong. Disbelieving investigators may subject alibi witnesses to coercive interrogation methods, which may pressure witnesses to retract or hedge the alibi. Police or prosecutors may threaten alibi witnesses with prosecution for perjury or obstruction of justice. Accurate, truthful witnesses may be intimidated and either hedge or retract their statements. Even more subtle methods can lead witnesses to retract an accurate, truthful alibi. Witnesses exposed to incriminating information may doubt their own memories or fear being seen as lying for the suspect and prosecuted, and soften or retract an alibi. Both truthful and false alibi witnesses may not recognize or respond when police test them with altered versions of earlier alibi statements. If counsel becomes aware of an alibi witness before a police or prosecutor's interview, counsel may want to take a statement to preserve the original alibi from further contamination by suggestion, post-event information, and pressure. If counsel first becomes aware of the alibi witness after a statement was given, counsel should see if the interview was recorded and talk with the witness to see if coercive tactics were used. Why didn't you go to the police? The alibi witness after arrest. Sometimes alibi witnesses do not go to the police and instead go to the defendant's family or defense counsel. In State v. Gear, the Connecticut Supreme Court stated that Although we do not believe that an alibi witness has a duty to report an alibi story to the police, or for that matter, to any other person, a witness in many instances naturally may be expected to convey such information, especially when the witness is friendly with the accused. Failure of the witness to do so would, under those circumstances, constitute grounds for impeachment because the failure to report an alibi under such circumstances is relevant on the issue of credibility or, more specifically, the issue of fabrication. A review of the Gear briefs shows that this assertion is based on judicial experience. Neither party provided the court with research into how alibi witnesses behave. The Gear opinion is akin to the historical belief discussed a decade later in State v. Trope that any normal woman would report a rape soon after its occurrence. The clear implication of this assumption was that if the woman did not complain, it was likely no rape had occurred. The Trope Court recognized that indisputably, one of the historic premises of the doctrine that it is natural for the victim of sexual assault to complain promptly following the assault has been discredited substantially in contemporary times. The overwhelming body of current empirical studies, data, and other information establishes that it is not inherently natural for the victim to confide in someone or to disclose immediately following commission of the offense that he or she was sexually assaulted. Alibi research does not yet have an overwhelming body of empirical studies about witness behavior, but there is enough research to suggest that those assumptions are flawed and should be abandoned. As one court observed, it is lamentable but undeniable fact of modern society that some of our citizens harbor a mistrust for law enforcement authority, which leads them to shun contact with the police, even when the avoidance of contact is not in their own best interest. Witnesses may be afraid of the police in general, or may have immigration issues, child custody issues, or pending criminal charges that make them particularly concerned about contradicting the police narrative. If the case has received significant media attention, the witness may be afraid of becoming part of the story. The witness may be afraid of disapproval from the victim's families or friends. Witnesses may believe that once the defendant has been arrested, going to the police or prosecutors, even with a strong alibi, will not lead to the end of the case. The further along the case is, the less likely it is that exculpatory evidence will lead to a dismissal instead of giving the prosecutor time to prepare an attack on the evidence. In the year 2000, a commission of inquiry was established in Manitoba, Canada, to look into the exoneration of Thomas Safano, falsely convicted of murder. The commissioner made a number of recommendations. As to alibi evidence, he suggested that the witness be interviewed by officers other than those involved in the investigation of the offense, that any interview with an alibi witness be recorded in its entirety, that the witness be treated with respect and courtesy, the witness should not be cross-examined, leading questions should not be used, police should not suggest that they are mistaken, threaten, intimidate, or influence the witness to change their story. No empirical research exists to show that alibis presented early in the criminal investigation process are better for an innocent suspect. To avoid good faith mistakes, an innocent suspect may want to wait until he or she can confirm the alibi, even if that means waiting until the eve of trial. Most jurisdictions have procedural rules requiring defense counsel to disclose an alibi to the prosecutor prior to trial. Counsel should keep these requirements in mind and make proper disclosures. Whether to offer an alibi defense. An alibi is not a traditional affirmative defense. It is a response to the prosecution's case. Logically, an accurate and truthful alibi means that the prosecutor's witnesses have misidentified an innocent defendant either through good faith witness identification mistakes or through deliberate lies by co offenders or cooperating witnesses. Alibi defenses may work well when combined with arguments about mistaken eyewitnesses, lying informants or cooperating witnesses, and investigative failures or omissions, including a rush to judgment and ignoring exculpatory evidence in the investigation. If the prosecution's case is based on physical or forensic evidence establishing that the defendant was at the crime scene, then even an accurate, truthful alibi may be unpersuasive. The defendant may have had innocent access to the area and left DNA or fingerprints prior to the crime. Video evidence is often unclear and may result in a mistaken identification. Forensic evidence may be tainted by confirmation bias if the examiner was aware of intrinsic inculpatory information at the time of the test. Counsel needs to consider the relative strengths of the prosecution and defense cases and the seriousness of the charges. Counsel should consult colleagues to see how the prosecutor in this case has cross examined alibi witnesses and argued about alibi in closing. Counsel then needs to think about the alibi witnesses and any corroboration of the alibi. Counsel should make the decision whether or not to present an alibi along with the client. Admittedly, decisions about which witnesses to call and what defenses to raise are traditionally within trial counsel's discretion. When a client is represented by assigned counsel, he or she has no right to his choice of counsel. Unless the defendant can show circumstances mandating a change of assigned counsel well before the start of trial, he or she either cedes to his assigned lawyer trial management decisions or waives his right to counsel. Those decisions included what arguments to pursue, what evidentiary case, and what agreements to conclude regarding the admission of evidence. In McCoy v. Louisiana, the defendant decides whether to plead guilty, waive the right to a jury trial, testify in one's own behalf, and forego an appeal, and sets the general objectives of defense. In McCoy, Justice Alito contends that the criminal justice system would break down if defense counsel were required to obtain the client's approval for every important move made during the course of the case. Among the decisions that counsel is free to make unilaterally are the following: choosing the basic line of defense, moving to suppress evidence, delivering an opening statement and deciding what to say in the opening, objecting to the admission of evidence, cross-examining witnesses, offering evidence and calling defense witnesses, and deciding what to say in summation. It is the client's future that is at stake in the trial. The client should have some input on the decision of whether or not to present an alibi defense. It may be important to the client that his or her family testify and demonstrate the client's innocence, even if that risks weakening the case. The final decision is counsel's, but if the client feels strongly about it, counsel should expect to have to defend the decision in post-conviction proceedings. In one survey of prosecutors, 81% of respondents said that alibis were only occasionally successful. 11% said that they were successful about half of the time, and 8% reported more frequent success. If the defense is aware of potential alibi witnesses but uncertain whether it will rely on an alibi defense at trial, then it may want to delay notice until a decision has been made. Notice must normally be given in time for prosecution to investigate the alibi witness. In outing, trial counsel was concerned about potential alibi witnesses who would say that the defendant was less than a mile from the crime scene shortly after the murder. None of the witnesses could pinpoint the defendant's location at the exact time of the shooting. In that case, deciding to offer the alibi witnesses and disclosing them to the prosecution could have weakened the defendant's case. Similar problems could arise if the alibi witnesses described the defendant wearing something like descriptions of the culprit around the time that the crime occurred. When did you realize you had exculpatory information? Witnesses who are casually acquainted with the defendant might not realize that they can provide an alibi. Witnesses may be uncertain about dates or times. For the witness, the crime may have occurred when he or she was doing something routine and had not paid particular attention to specific times or places. Sometimes the exact time or location of the offense is uncertain. Not only could witnesses be unsure if they could provide an alibi for that time, investigators or forensic experts who become aware of a strong alibi may subconsciously reconsider the evidence and change their estimate of time or location to still support the defendant as culprit. I know this isn't going to have the audacity to not let me finish. Did you have a
Here we go.
motive to exonerate the defendant? Most alibi witnesses are the defendant's family, friends, coworkers, and other people who know the witness well. They call these motivated witnesses. This is normal. One spends the most time around one's family, friends, and coworkers. Unfortunately, police and jurors tend to be skeptical of motivated alibi witnesses. If the crime took place during business hours on a weekday, the suspect's alibi witnesses are most likely his or her coworkers. If it took place late at night or on a holiday, then the suspect's alibi witnesses are most likely family. Expecting the suspect to be able to provide neutral alibi witnesses for most dates and times is unrealistic. Would you lie for the defendant? What about the popular assumption that friends and family are likely to lie for the defendant? In one study, 62% of jury eligible participants felt a biologically related alibi witness would be most likely to lie for a defendant. 50% felt the same about someone related by marriage, and 32% felt the same about witnesses socially related to the defendant. There is some research about when people are willing to provide false alibis. In one study, 23% of participants were willing to corroborate a false alibi, regardless of how much they liked the suspect. Witnesses were less likely to lie when the witness had seen evidence pointing to the suspect's guilt than when there was ambiguous evidence of guilt. Unfortunately, truthful witnesses are more likely to retract an accurate alibi if exposed to incriminating evidence. It is really hard to separate an alibi provided in good faith from a lie. Study after study shows that people are not good at accurately assessing deceit. In most cases, investigators and fact finders would be just as accurate if they flipped a coin. This makes it hard for investigators and fact finders to assess an alibi witness. The DNA exoneration cases suggest that there is a systemic bias in our justice system against alibis provided by innocent suspects. Could you be mistaken? The police or prosecutor may suggest that an alibi witness has made a good faith mistake, confusing the date, time, or identity of the defendant. It is not an unreasonable argument. The alibi witness had no reason to realize that he or she would have to recall details of their interaction with the defendant days, weeks, months, or years later. Counsel may want to look at the eyewitness identification case law in their jurisdiction to ask for jury instructions on perception, memory, and the effects of after acquired information and suggestion. The jury should have some guidance about how much accuracy they can realistically expect from a witness, be it the prosecutor's eyewitness or the defendant's alibi witness. Can I offer an expert witness? If your jurisdiction allows you to offer an eyewitness identification expert, you should be able to offer an expert to talk about how perception, memory, suggestion, and so on work in the alibi witness context. If the prosecutor's case is built on flawed eyewitness identification testimony, then you may already be planning to offer an identification expert and can ask your expert if he or she can also look at and talk about alibi witness research. Closing argument. Prosecutors are given significant discretion to comment on alibi witnesses in their closing argument. Expect the prosecutor to ridicule your witness. Be wary of prosecutorial closing arguments that stray into impropriety by vouching for the state's witnesses, improper comment on prosecutors' belief in defense witnesses' credibility, improper attack on defense counsel as suborning or soliciting perjured alibi, shifting the burden of proof. Prosecutor can recount testimony about police attempts to contact alibi witnesses without shifting burden of proof. Implications that the defendant or alibi witnesses had a duty to come forward to police. This can become an improper comment on the defendant's right to remain silent. The prosecutor arguing about what he or she would do to protect a loved one, object to improper arguments, ask for curative instructions, and preserve the record for appellate review. In conclusion, alibi is an important defense for the innocent defendant. Prosecutors and judges are skeptical of alibi witnesses, perhaps overly so. Defense attorneys seem reluctant to offer all but the most rock solid of alibis. The result may be a loss of accurate, truthful alibi testimony supporting innocent defendants. There are a growing number of research articles about the psychology of alibi witnesses and how they are perceived by investigators and jurors. As yet, research does not know much about how easily or often alibis are fabricated, whether they are reliable cues for an investigator or fact finder trying to evaluate an alibi, how jurors actually react to incomplete or partial alibis, and how well jurors follow jury instructions when weighing alibi witness testimony. Investigators and prosecutors should consider the effects of investigative bias and tunnel vision when they evaluate an alibi witness. The Softenau recommendations to fairly evaluate an alibi should be used more often. Investigators and prosecutors should be prohibited from threatening alibi witnesses with criminal charges. Defense counsel should investigate an alibi witness, even if he or she is skeptical about using an alibi at trial, and document that investigation. If counsel decides to present an alibi defense, then he or she should carefully prepare the witness for contact from the prosecutor and or police after disclosure, and for inevitable cross-examination questions at trial. Counsel should be prepared for a vigorous closing argument and alert for prosecutorial misconduct or impropriety in cross-examination or closing. Counsel should consider expert testimony about perception, memory, particularly autobiographical memory, suggestion and after acquired information, and good faith mistakes in appropriate cases. Courts and counsel should consider jury instructions about perception, memory, suggestion and after acquired information, and good faith mistakes to give jurors a proper framework to evaluate prosecution and defense witnesses alike. Thanks for listening. Man, that was rough. Whoever replays it will have a better time because they can just skip through all the bullshit. All right, so these filings. Let's look at these filings. Can't believe some of y'all haven't seen these yet. So there were a couple that went through. So one I told you all about already is that the prosecution says that they have no problem giving till the 24th of July to provide the alibi, um, which I believe the 21st of July is when they have to file their whether they're going to seek the death penalty or not. So I guess it's a little bit interesting that they let it be after that, unless it falls on a weekend. I'm not sure. Shouldn't matter though. Then there was, let's see. Did you guys like that? I mean, I know it was hard, but did you like learn anything? Oh, good. I'm gonna have to. I'll figure out how to just post it like as it is. So there were. We don't need that one. We don't really need. Okay, so there's really only two that we need to go over. So there's a defendant's reply to the state's supplemental response to his motion regarding the grand jury record and transcript. And then there is a motion to stay proceedings. So let's look at this. We'll do their reply to the state's supplemental response first. Mhm. Whoa. How's that? Oh, good. Did it take me fully off the screen? Good. All right. So, do you want me to read this? I'm going to read it. It says, comes now Bryan C. Kohberger by and through his attorney Ann C. Taylor, public defender, and hereby replies to the state's supplemental response to defendant's motion regarding grand jury record and transcript. Come back on the screen. Let me see. I'll put my picture up. Sometimes we have people that like literally cannot see. So I try to get me away. Oh, you know what? Boop. There I am in the corner. Okay. Um, okay, the state argues that Mr. Kohberger is only entitled to an audio recording and or transcript of the grand jury proceedings and the grand juror notes, but not the other enumerated items set forth in Idaho Criminal Rule 6 whatever. If y'all remember, I had posted it was like a white collar crime, some kind of white collar crime. I had dug and dug and dug and finally found a whole ass basically case file of these people in, I believe it was Kootenai County, who I was basically trying to find that actual filing that she filed that had all that information. And there were people that were saying that she was asking for above and beyond anything that's normal. But then when I found that case, I was like, okay, well, it's literally word for word exactly the same as what she filed here for the Kohberger case. So obviously, it's not that abnormal because she pulled up the filing and changed his name and sent it off to the judge. Um, and interestingly enough, again, that was a white collar crime. They also stood in silence at their whatever it's called, arraignment. So this gets good. It says the state also objects to a qualified protective order, preferring instead to keep requested materials protected by adherence to the word sealed. Release of the grand jury proceedings governed by rule and statute are materials necessary to Mr. Kohberger's defense. Article 1, Section 8 of the Idaho Constitution, Idaho Criminal Rule 6, and Idaho codes provide authority for release to Mr. Kohberger. Good cause is not required, but exists to release all items in Mr. Kohberger's motion as set forth below. Yes, I can remove it, maybe. Lord, it was so long ago. Oh, there. Okay. You guys are teaching me everything. So, procedural background. Mr. Kohberger was indicted by a grand jury on May 16th, 2023. He filed a motion to make available the record of all proceedings of the grand jury pursuant to Idaho Criminal Rules 6.2 and a motion requesting release of grand jury materials under qualified protective order. On May 19th, 2023, the state then filed their state's response to defendant's motion regarding grand jury record and transcript and a proposed order on May 30th, 2023. The parties were not able to reach an agreement regarding the release of grand jury materials, which resulted in the states filing their state's supplemental response to defendant's motion regarding grand jury record and transcript on June 6, 2023. This defense's reply follows. Here's the argument. Number one, Mr. Kohberger has a legal right to challenge the grand jury indictment, and the court shall release all records requested in his motion. Mr. Kohberger faces charges of 4 counts of first-degree murder and 1 count of burglary. Because of the first-degree murder charges, the state can file notice of intent to seek the death penalty. After Mr. Kohberger's early January court appearance, counsel for Mr. Kohberger and the state planned for a preliminary hearing scheduled the week of June 26, 2023. A preliminary hearing would have allowed the defense to challenge evidence the state claims to have against Mr. Kohberger. The state, as is its option, chose to proceed with a secret grand jury. A grand jury was impaneled at a time when the small community of Moscow, Idaho, had been exposed to 6 months of intense local, national, and international media coverage. Because the state has provided extensive discovery, Mr. Kohberger knows that exculpatory evidence exists. Whether a fair and impartial panel of grand jurors was assembled amidst intense media coverage is a significant question the defense must evaluate. Whether inadmissible or exculpatory evidence was presented to the grand jury is a significant question the defense must evaluate. And then they direct you to different Idaho criminal rules. And while there are many other legal arguments Mr. Kohberger may pursue related to the grand jury proceedings, how the grand jury was selected, and what evidence was presented illustrate good cause for the defense's need for all materials set forth in its motion. Mr. Kohberger is entitled to pursue relief on a single error or cumulative errors. To determine if there are cumulative errors, good cause exists to review all items requested in his motion. Cumulative error exists when the cumulative effect of the errors and indiscretions, none of which might have been enough to tip the scale, operate to the defendant's prejudice by producing a biased grand jury. Noting under the doctrine of cumulative error, a series of errors, harmless in and of themselves, may in the aggregate show the absence of a fair trial. Pursuant to Idaho Criminal Rule 48, Idaho Code 2-21, Mr. Kohberger is entitled to request the proceedings be stayed while he challenges the indictment. The rules provide for the release of all enumerated items in Mr. Kohberger's motion without good cause. Mr. Kohberger is requesting items listed in Idaho Criminal Rule 6 and Idaho Codes 19-1001, 2021, 1201, 1401. Mr. Kohberger is not seeking anything outside of rule or statute. Each portion of the grand jury proceedings is specified in his original motion and in the rule. See motion to make available the record of all proceedings of the grand jury pursuant to Idaho Criminal Rule 6.2. And that was filed on May 19th. The state's suggestion that he should listen to the audio recording and or review a transcript of incomplete proceedings merely adds delay to Mr. Kohberger's ability to challenge the grand jury indictment. Essentially, Mr. Kohberger is asked to, quote, look at some but not all, and then ask for more at a later time. Mr. Kohberger's right of a speedy trial has not been waived. This sort of delay would require either a waiver of his important right to a speedy trial or for counsel to represent him less than fully prepared. As such, Mr. Kohberger, under separate but contemporaneous filings, is requesting that his case be stayed during the now contested process of obtaining materials he must examine. Authority for a stay is contained in Idaho Code 2-213, subsection 2. A party may move to stay the proceedings and in a criminal case to quash the indictment or for other appropriate relief on the ground of substantial failure to comply with this chapter in selecting the grand or trial jury. Mr. Kohberger is acting with diligence to discover grounds upon which to challenge the indictment through a motion to dismiss. The state's obstruction of release of the full grand jury proceedings is creating unnecessary delay. This case should be stayed until Mr. Kohberger has complete access to all materials related to the grand jury proceedings and until such time as he can file an Idaho Rule 48 motion to dismiss the indictment. Or, as Mr. Kohberger is requesting, the court shall order all jury records released so that the defense work can be done. The state's reliance on state v. I'm assuming it says Abdullah for the standard that good cause is required is not accurate. Of course, they wrote it literally in every sentence, so I really hope I'm saying it right. Mr. Abdullah's grand jury proceedings were in 2014 before Idaho Criminal Rule 6.2, which was adopted in 2017. The rule does not require good cause, and even if it did, good cause exists as explained earlier. In Mr. Abdullah's post-conviction case, he was arguing that grand jury transcripts that had not been included in the appellate record needed to be added and briefed as a subsequent issue. Mr. Abdullah wanted to argue that the grand jury term had expired. In this case, Mr. Kohberger is asking for grand jury records immediately following his indictment and before jury trial, not years later in a post-conviction proceeding. It is worth noting that Abdullah illustrates how issues such as this have plagued cases in the appellate realm for decades. Release of the grand jury records now allows Mr. Kohberger's defense to provide effective representation. Mr. Kohberger seeks access to these records whether sealed or under a qualified protective order. Defense counsel needs to be able to disclose the grand jury records to the defense team, including relevant experts, with the admonition that the records are not to be copied or dispersed. Defense counsel needs to be able to review the records with Mr. Kohberger, but does not seek an order to provide him with a copy. Additionally, the defense needs to be able to refer to the records in legal challenges or witness examination. To protect the sensitive nature of the records and pleadings referencing grand jury proceedings, any such proceedings can be submitted to the court with a motion to seal. Conclusion. Mr. Kohberger is entitled to review all grand jury proceedings as set forth in his original motion to make available the record of all proceedings of the grand jury pursuant to Idaho Criminal Rule 6.2, filed May 19th, 2023. Although good cause is not required, it exists because a grand jury was impaneled after 6 months of intense media coverage in a small community. Exculpatory evidence exists, and there may be a single error or cumulative errors which require the examination of the entire grand jury record. He does not object to the records being sealed as clarified earlier. He agrees with the statute that grand juror notes should be included in the records provided. Should the court release only partial records or transcripts, Mr. Kohberger requests a stay of all proceedings pursuant to Idaho Code 2-213 until such time as he is able to review, request additional records, provide a sworn statement of reasons, and file an Idaho Criminal Rule 48 motion to dismiss. So that was yesterday, and they just posted it today. And then any thoughts on that? I mean, like, I'm not surprised. I just think this is all so interesting. And I saw someone say something about how vital the knife sheath is or whatever. I got a couple things to say because I was like making a list today, and I think there's some things that either most people don't realize or maybe want to argue, I guess. I'm not sure. Um, but just certain little things, particular about the probable cause affidavit. But let me share this one. It's way shorter. This is the motion to stay the proceedings. Okay. Yeesh. Okay. Comes now Bryan C. Kohberger, by and through his attorney, Ann C. Taylor, public defender, and hereby moves the court to stay all proceedings in this case pursuant to Idaho Code 2-213. Mr. Kohberger was indicted by a grand jury on May 16th, 2023. He filed a motion to make available the record of all proceedings of the grand jury pursuant to Idaho Criminal Rules 6.2 and a motion requesting release of grand jury materials under qualified protective order on May 19th, 2023. The state then filed their state's response to defendant's motion regarding grand jury record and transcript and a proposed order on May 30th, 2023. The parties are not able to reach agreement regarding the release of grand jury materials. In further opposition of Mr. Kohberger's motion for the preparation of grand jury records, on June 6, 2023, the state filed their state's supplemental response to defendant's motion regarding grand jury record and transcript. A hearing is scheduled for June 26th to argue this contested matter. Mr. Kohberger stood silent at his initial hearing to preserve his right to contest the indictment. He also asserted his right to a speedy trial pursuant to the United States and Idaho constitutions. Jury trial is scheduled to begin October 2nd, 2023. Time is of the essence. By the time this court hears argument on the preparation of the grand jury proceedings, almost 6 weeks will have passed from the time of the indictment. Preparation of the grand jury record will then take additional time. Mr. Kohberger has the right and intends to contest the indictment. Idaho Code 2-213, subsection 1, allows the defense to seek a stay of proceedings within 7 days after the moving party discovers, or by the exercise of diligence could have discovered, the grounds therefore, and in any event before the trial jury is sworn to try the case, a party may move to stay the proceedings and in a criminal case to quash the indictment, or for other appropriate relief on the ground of substantial failure to comply with this chapter in selecting the grand or trial jury. Mr. Kohberger seeks to stay the proceedings as appropriate relief while the matter of the grand jury record is argued and prepared. He is exercising due diligence to discover the grounds upon which to file a motion to dismiss related to how the grand jury was selected. And then there's this thingy that takes you down to the footnote. And the footnote says Mr. Kohberger will comply with filing a sworn statement of facts in accordance with IC 2-213, subsection 2, as soon as he has the grand jury record. He is being delayed through no fault of his own. Mr. Kohberger's request to stay proceedings until the grand jury record is prepared and he has adequate time to contest the indictment should be granted. The remedies allowed in Idaho Code 2-213, subsection 3 are the exclusive means by which a person accused of a crime may challenge a grand jury on the ground that the jury was not selected in conformity with this chapter. A stay of proceedings is appropriate. So the way I understand it is that, like, no other filings or anything can be done, like, nothing can happen if they were to grant the stay of proceedings, nothing can be done until that is up. I don't know, I think Ann's a badass. Like, regardless of, like, on other cases, too, I'm sure, like, if I was gonna have a public defender, I would hope and pray it'd be somebody like that. Unless we, like, get to trial and she proves to be just totally incompetent and somebody else is writing this, then I must say that I am impressed. I wanna I wanna say something about the about the probable cause affidavit. Hold on, let me resituate myself. Hold on. I literally was like so I'm surprised I could even sit up. I was in the most uncomfortable I had just, like whenever it wasn't working hours ago, I leaned over to try to get it working again and was, like, in one spot, like a roly-poly for the past hour. I was like, "I gotta readjust myself," and then when I went to, I it felt like it wasn't gonna let me. Oh, do not get old. Okay, so the probable cause affidavit. So we were talking about this earlier, and, for anybody that was here when we were talking about this last live, I brought up that in order for the car to have passed the house 3 times and then leave, I am flexible, it's just then getting out of where I was at. I could get there, it's just hard to come back out. Okay, so, we were talking about if the car was gonna pass 3 times, um, on that road where there's only one way in and one way out, and I showed it on a map, um, that it would have had to have originated in that neighborhood or behind the house. So, if you pass 3 times, the car was already in the neighborhood or behind the house or at the apartments, but it didn't come from Taylor Avenue because had it come from Taylor Avenue, it would have came and passed the house, uh, and headed towards the dead you know what? Fuck it. Hold on. That's really why we're here is I mean, we have spaces, but when I wanna show you stuff is why I come over here. So, while I'm pulling that up, I was thinking, like, if that were the case, it would most certainly better fit the profile that was coming through, not just by the people that were on the news and whatnot, but also us, like, behind closed doors. I know that we had plenty of discussions where we were like, "It just doesn't make any sense." It was unusually quiet, right? So, if this person had been stalking them, then they would know that no one was in the house unless they let some strangers or other kids in the house to do whatever while they were all gone. The house was empty until 1 when the 2 surviving roommates got home, right? So, we were like, that person probably, like, sat behind the house or hid in a bush or whatever, until all the lights went off and everybody got home, and then they got out and or they were ballsy and they when everybody wasn't home, they went in and they, like, stayed in a closet or something, right? Until everybody went to sleep and then jumped out and attacked, but they were maybe in the wrong room. Like, that was what everybody was thinking. So, then we get this affidavit and it's like, "Okay, so you're saying that he never even left his house until everybody was home? Why wouldn't he have if he had planned this, why wouldn't he have taken the opportunity to have gone there prior to anybody showing back up at the house?" So, I'm reading the affidavit. Okay, I'm zooming in. I'm at the house. I will show you guys the house in a sec. So, I'm, like, reading the affidavit and I'm like, "Okay, so 3 times." So, it started behind the house, which was exactly what we were thinking had happened. Uh That makes more sense to me. The only problem is if you're gonna believe that, if you're gonna read it how it is, and you're gonna take it for what exactly it says without, like I said, most of the things there, we have to jump to conclusions instead of just being given factual and, uh, clear statements, right? It's a probable cause affidavit. You're accusing someone of something, so you should be able to point out step by step what it is that's leading you to believe that that person is guilty, right? So if we're looking at the house, which is right here, and we're looking at the affidavit, which I will pull up. I know we already did this, so we'll make it super quick. All right. So in the affidavit, when it's talking about the car's movements, the first time that the car is ever seen on camera, like in this neighborhood, is at 3:29. So it says, a review of footage from multiple videos obtained from the King Road neighborhood showed multiple sightings of suspect vehicle 1 starting at 3:29 a.m. and ending at 4:20 a.m. These sightings show suspect vehicle 1 makes an initial 3 passes by the King Road residence and then leave via Walenta Drive. So, if we do, here we are in the car, right? Here we are. If you go up a little bit further, it says that at 3:28, so 1 minute prior, this car is seen plumb over here at Steiner, right? So you're trying to imply that it's the same car. So you're saying 3:28, 3:28, 3:28, 3:28, 3:28, 3:28, 3:29. Here we are. We're here in the neighborhood. Okay. 3:29. We're here. Now we're going to make 3 passes and we're going to leave via Walenta Drive. We passed the house one time. We can't get out here. I want to make that clear. Can't get out here or here or here. Like it's one way in, one way out. We have to go back out to Taylor Ave. We passed the house one time. We pass it a second time. And we pass it a third time. We cannot leave via Walenta Drive because Walenta Drive is over here. We would have to pass a fourth time to leave. Okay. So in order for this affidavit and these passes to be true, it would have had to start either back here and behind the house, like we had thought, or over here. And it would have passed once, it would have passed twice, and it would have passed a third time and got the fuck out of there via Walenta Drive. Okay. So there's that. And how we know that it didn't pass another time, starting here, pass 1, 2, 3, and then, oh shit, now I'm stuck back here, pass a fourth time. The reason we know that that didn't happen is because the affidavit goes on to say that it talks about the 3 passes. And then it says, based off of my experience as a patrol officer, this is a residential neighborhood with a very limited number of vehicles that travel in the area during the early morning hours. Upon review of the video, there are only a few cars that enter and exit this area during this time frame. Suspect vehicle 1, and keep in mind, I also think this kind of got past me the first couple times. Like they're saying that this car it left, so it got out of here, okay. But it doesn't say. So it's seen at 3:29, but it doesn't say how many times it takes for it to drive by 3 times. You know what I mean? Did it take like 30 seconds and then it got out of here and then it took all the way till 4:04 before it appears again? Because the next paragraph says suspect vehicle 1 can be seen entering the area a fourth time at approximately 4:04 a.m. Right? So it could have been, I mean, 3 passes could have took 30 minutes. 3 passes could have took 30 seconds. It could have taken 3 minutes, 2 minutes, 10 minutes. Like there is no, if you're looking at this on a camera, then you have timestamps. I don't, if you're establishing a crucial moment, which is your 25-minute time frame of a murder having happened, and you're going to establish it for that whole hour prior, right? Because you're saying that you saw this car. So now you're trying to establish premeditation. That's what they're trying to do, is that he was going by a couple times and then he hesitated. Like that's meant to say that he thought about it for a second and decided to do it anyway. So it comes back in the area at 4:04. Okay. Then it says it can be seen driving eastbound on King Road. Wait a minute. Let me make this a little smaller. Can be seen traveling eastbound on King Road, which this is fucking King Road and it's north and south. So if you didn't know, like I keep these labels off because like this isn't King Road. So, but for our purposes, it is. So it was traveling east, it was going towards these apartments. It then stopped and turned around in front of 500 Queen Road, number 52, and then drove back westbound on King Road. When it gets in front of the house, it does whatever this weird thing is where it unsuccessfully attempts to park or turn around in the road, whatever that means, and then continued to the intersection of King and Queen, where it completed a 3-point turn and headed back eastbound again down Queen Road. Suspect vehicle 1 is next seen departing the area of the King Road residence at approximately 4:20 a.m. at a high rate of speed. Nowhere in there does it even say that this car was out of sight of the camera. It doesn't say that it stopped anywhere. It doesn't say that it parked. It doesn't say that anybody got out. And like I said, I think the main thing for me is that it doesn't say that it couldn't see the car anymore. So if we can see the car the whole time during the 4, and what's interesting is that at 4:04, you know that he's driving around. You know that the car's driving, and at 4:20, you know it's gone. So you're already losing 10 minutes of their 4 to 4:25 time frame of the murders, right? It's impossible that it could have been him between 4 and 4:05, right? Because he was driving. And it couldn't have been. He couldn't have done anything after 4:20 because he was already speeding out of there at 4:20. So my question is when you're writing, I understand that like a probable cause affidavit isn't meant to convict someone. It's not meant to like establish guilt, I should say, just probable cause to believe that a crime happened and that you did it. Wouldn't you think that like a major part of that would be establishing that you ever got out of your car? I don't even know he ever got out of his car. And when we were trying to determine like, so we're like, okay, he was seen at 4:04. So like maybe he got out of the car at like 4:05 or 4:06. Well, I would say that that's probably not so, being as how he had to do all these maneuvers. He was seen at 4:04 and then he was driving down Queen Road. Then he turned around. Then he tried to stop or park and then couldn't. Then he made a 3-point turn. So like it could have been multiple minutes that went by anyway. So we're cutting that time down more narrow, more narrow, more narrow. But for me, what was most important is that it does not say, we just assumed, we jumped to a conclusion that at some point between 4:04 when it's seen and 4:20 when it's seen pulling away, that it must have been out of sight at some point. See, because our brains work that way, right? Like we fill in the gaps. So if we're reading a story and it's missing a bunch of the story, our brains are gonna fill it in. So when you tell me that you see a car at 4:04 and that it speeds away at 4:20 and that you believe that the time of the murders was between 4 and 4:25, my brain is gonna say, "Oh, shit. Well, then at some point, it must have gone up into the trees in the back parking lot behind the house because 'cause there's gotta be a reason, that they think that it was him, and so he must have been out of sight of the cameras." I did it too. Because my brain doesn't like things that don't make sense or, like, are incomplete. So, my question is how do we know that this person in this car got out of the car? Or that it was ever I won't even do that. Let's say I won't even say that it needs to go that far for me to have seen someone get out of the car, let's just say. How do we know where was the opportunity for this person to have got out of the car per the probable cause affidavit? Like I've always said, I'm like, why on earth would they assume? Like, what made them think that the person that was driving this car was also the one that committed the murders? Because it wasn't the only car that was around, right? I mean, we know at least there was a DoorDash driver. If there are 2 different cars, there was at least a DoorDash car at the same exact time driving around, and it wouldn't have just been driving around this neighborhood. It would have been driving around other neighborhoods. Driving around does not mean that you've killed someone, and it's also not illegal. And also, in the body cam footage, like, you can see the police were out there. There were people walking around and behind them in the background of the footage not 20 minutes earlier. So it's, like, not abnormal. It wasn't abnormal on a Saturday night for people to be out and about in this neighborhood. So what made you think that the police or what made you think that this car was carrying the individual or individuals that killed those kids? Is it because you put out that you were looking for this car? And when no one came forward to and I'm just throwing this out there as my speculation of what it might have been that led them to that conclusion, because I really can't figure out why they would've. I still don't understand why we're not thinking that they were on foot. I don't know why you would drive your car to a quadruple murder. He's a runner. Why didn't he park at, like, the Arboretum and fucking run over there? That makes no sense. So, but regardless, did you announce that you were looking for this car? And because someone didn't come forward and say, "Yes, I have that car, and I was in the neighborhood," did you automatically say, "Well, now that person's sus," and probably did it because they didn't come forward? Is that what happened? If the maneuvers of this car really does sound like like driving in a neighborhood you don't know where you are and you, like, turn the radio down because like, it'll help you find directions better, and you're, like, peeking out the windows trying to see if something looks familiar, like, if that's where you're supposed to be. So, I'm curious, and this has nothing to do with, like, the PCA unless you wanna talk about the fact that they didn't put any information about the DoorDash driver in there, so whatever they were driving. Um, what did they look like driving around? Did they know exactly what house they were going to? Did they pull right up? Did they pull into the parking lot? Did they park in behind the house? You see what I mean? Did they see this person, like, driving around, or was it a Door Dasher that was lost? Didn't know where they were going? But my main point is that in the affidavit, it does not say that the car was out of sight of the cameras, and it tells you about all of these maneuvers. So, for me, instead of just assuming that 3, 4 minutes out of those maneuvers, someone happened to get off camera, get out of their car, go in a house, uh, kill 4 people on 2 floors, and then go past a surviving eyewitness who never said that he was running. So he was walking and did all of this in 4 minutes, got back in his car, and then decided to speed away after, like, all these normal maneuvers and walking through a house. They decide to get in a car and, like, peel the tires. That doesn't make any sense to me. Um, it's more, uh to me, it makes more sense if I'm reading it to just assume that they saw the car the whole time, 4:04 to 4:20, and then left. My other thing is the murder weapon. If I'm gonna write a probable cause affidavit, and I'm gonna tell you that 4 people were stabbed to death, and I'm going to tell you that I found a sheath to a big knife in between 2 of the deceased victims, and it had somebody's DNA on it on the button, okay? At that point, I've already had the autopsy reports, right? So, I would know for sure based off of my conversation with the pathologist as well as the autopsy report, I would know if that knife that fits that sheath that has that person's DNA on it is consistent with the wounds on the victims that they died from. So when I'm telling you that I have a sheath, I'm going to tell you that I have a sheath that typically holds a knife and that that knife is consistent with a weapon that would have been used to create the wounds on my victims. Otherwise, I'm basically saying, and we've brought up this analogy before, like, otherwise, I'm basically saying, like, if they would have found a gun in between the 2 girls and it had somebody's DNA on it that was not someone inside that house, and they were stabbed to death, they weren't shot, but we're arresting whoever's DNA was on that gun just because it was a weapon and it was there, even though it's not consistent with the wounds, right? It's just something I found interesting. There's things that I would want to establish. Um, a lot of the probable cause affidavit is based on my training and experience. Based on my experience as oh, goat hair. Bless your heart. You must have just got here and you're gonna try to rewind because it's hard. We tried muting the mic. We tried everything. Um, but I forget what I was saying. Oh, as many so a lot of them is like, uh, based on my training experience as an officer, based on my experience as a patrol officer, I can jump to this conclusion, and that conclusion. So, could we not get, like, a conclusion about how the suspect entered the house to do this? Or how they're believed to have left the house? You got Dylan taking us to the door. She's like, he was walking towards the door. I'm gonna read this again. Maybe there's gonna be somebody in here that could explain this sentence to me. I'm gonna read it again. I'm still super confused. And I assure you that for as bad as I did on, like, math and stuff in school is how excellent I was with reading and reading comprehension. And I don't know what the fuck this says. So I'm gonna read it and maybe somebody else does. I'm sorry if you've already had to had to listen to me ask this before. So we're talking about Dylan, and it says, "The male walked towards the back sliding glass door. DM locked herself in her room after seeing the male. DM did not state that she recognized the male. This leads investigators to believe that the murderer left the scene. What does each sentence have to do with the other?" And not for nothing, but Ken on my Twitter brought this up today and said, if DM locked herself in the room after seeing the male, how did she see them go to the back sliding glass door? Or did she only see him go to the back sliding glass door, then she locked herself in the room? Okay, that's probably what she did. So, but she didn't see him leave. But then my other question is her bedroom window is pointed directly at that back parking lot, like straight at it. So, did she see headlights turn on or hear a car start? Anything to lead you to believe that the killer would have left? Only reason they put the statement in there is to try to establish she is a witness because of the shoe print they found and try to convince everyone she's not lying. So, to a degree, I believe that. Uh, there's just a couple other things. So, like, one thing is not providing any additional information about this shoe print. Like, was it one shoe print? Like, was it a one-legged killer that only left one shoe print? Or were they in, like, one potato sack? Like, they had one leg in a potato sack? Or I'm just not I'm not understanding how you would find one shoe print, and also, um, maybe if you didn't know, like, exactly the size, like, shouldn't you know the size? Like, shouldn't you be able to say, at the very least, shouldn't you be able to say, it appeared to be a male size shoe, a male size shoe print. Doesn't this motherfucker wear like a size 13? How big are these girls' feet inside the house? My other question is where is, and I'm sorry this is just turning into like Sleuthy's questioning session, but like I've got questions. So he has boats for feet. That's what I'm saying. That's what I'm saying. And but also where's the other one? How do you have one? So even if you didn't want to like trap yourself into like a specific size, like I said, I feel like it wouldn't have hurt nothing if you knew that it was a male. Wait a minute. I don't know this for a fact. I mean, because pictures are deceiving, but I will say that she is very tall, and I'm tall, but I'm not that like I'm taller than most people think that I am. I don't know why everybody thinks I'm like really small, but I'm not. I'm 5'7", but my cousin, she's 5'10", and she's got big ass feet. She wears like, I'm not trying to offend nobody, but you got to be proportionate, right? So the taller you are, the bigger your feet got to be to keep you steady. That's just simple science. She's very tall. I wouldn't be surprised if she also wore like a size 10. Well, a size 10 in a female and a boy's or a man who wears a smaller shoe would be hard to tell. But by God, a size 13 should have looked like a man's size shoe. So, but also, while we're on the shoe subject, where's the other shoe print? And I know that latent means it wasn't visible, but that could be for a number of different reasons. But essentially, for this crime, where there was said to be blood literally everywhere, we aren't talking like um, wiping your shoe, like wiping the bottoms of your shoes off on a rug and then tracking very, very minute amounts of blood. And we don't even know that that's what it is. I mean, we know that it like presumptively they did like a presumptive blood test and then used Amido Black, but Amido Black will pick up things that aren't blood. But my question is where is this individual's other shoe prints, and do they also corroborate Dylan's version of what path he took? Because like wherever he started, so if he started upstairs on the third floor, he would have tracked something down the steps. If he would have started on the second floor, he would have tracked them up the steps and then back down the steps. You'd be able to tell exactly where they went to first. Um, but what about everybody else's shoes? What about all the people that were there when 911 was called? What about when Dylan left her bedroom? When she left her bedroom, she would have been right in the path of wherever this person had walked and tracked DNA through the house. So it seems like it would be, for me, like unfathomable that there would not be her footprints that were carrying something around the house that would need to be taken accounted for. So like they would need to be like checking the bottoms of the soles of her feet, her shoes, and use those for comparison as well. Just like whatever law enforcement people went in there and didn't have booties on. Or when it snowed a whole bunch and they were in and out of that house, taking things out and putting them into a U-Haul, saying that they were going to be giving it back to the victims' families, which I cannot imagine and still don't believe. I don't know if that was how they were like secretly going to get evidence out of the house while the media was outside. So they were like using the families as an excuse. Like, listen, we're bringing out like their loved ones belongings. Like, please don't make this like a big scene and zoom in on everything. I don't know. I don't know. I feel like if you're gonna ask me to believe, if your purpose is to ask me to believe that this person killed these kids, that's fine. But you gotta at least tell me, like, when they had the opportunity to go inside. The fact that I'm sitting here in June, or we're sitting here in June, and we don't know, like, how he knew them, or why this was targeted, or how he got into the house, or what, what even specific, like, path that he took, or what even the murder weapon is. We don't know that it was a K-bar. We all jumped to that conclusion because they found a sheath, and we were like, "What the fuck would a sheath be doing in the middle of 2 dead people if it wasn't the one that was holding the murder weapon?" Because 'Cause we've got brains that like common sense. It doesn't make sense for it to be there unless it was used, but we don't know that, and in all of their subsequent search warrants, they're looking for other things. They're looking for swords and, like, shivs and stuff. So, I mean, it almost seems like this is interesting. So, this whole, like, there was something that was going on and people were trying to say that the sheath was gonna get thrown out, blah, 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 blah. And I was talking to Bob Mata, and he was like, "I don't know why everybody's saying this." And I was like, "I don't know why either, but let's talk about this because I have a question." I know that it has his DNA on it, which we don't even, like, know for certain, right? I mean, we know that it has a profile on it that they're telling us the trash DNA that they gathered that's only in one affidavit, which is the arrest affidavit, that that trash DNA, we don't even know if it was dad's DNA. We just dug in the trash, we found a DNA and said that it was like 96. I have it open, like, it was like 96 point something or 98 point something. 99.9998% of the male population would be expected to be excluded from the possibility of being the suspect's biological father. That's what the sheath DNA was the suspect's biological father. And just something interesting with numbers is I was curious about that because I was like, "Damn, 99.9998." So, but then, like, when you look up the male population and, like, the male population, let's say over 18 years old, yada, 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 in the United States, because that's what they're talking about is the male population of the United States. That still leaves, like, 300 and some odd people. I know it's super small, but it's just the little details that are interesting to me. Um, so I said to Bob, I was like, "If they find out." So, if that knife that fits in that sheath is not consistent with the murder weapon, does that sheath itself, and subsequently the DNA that's attached to it, become irrelevant? And he told me that no, it would likely still be brought in, the sheath and the DNA both. And what it would boil down to was basically like a battle of the experts. So essentially, the prosecution's expert would, well, first they would put on the forensic pathologist, and then she would get hammered on whether or not the knife that fits in that sheath is consistent with what caused the wounds on the victims. If she can't say for certain and she says, well, it could be, it's like one of the ones, then the defense is going to argue essentially to the jury that Well, his DNA was on that sheath, but she's telling us that there could have been a different murder weapon. So, what does that sheath have anything to do with it if it was a different murder weapon that they still haven't found? So, I thought that was really interesting because I kind of thought, I guess I thought, I was thinking back to like the gun analogy. And I'm like, if the gun was found and it wasn't consistent with the murder weapon, then what would it matter whose DNA was on it? Right. Um, so in my head, I'm like, to me, it would be irrelevant. And to him, he's like, "No, it would still go in," but it's a perfect example of how a jury thinks, right? So, if I was sitting there on the jury and they told me that they did not have anything that said that it was consistent with the wounds, then, right off the bat, I'm gonna be like, "Well, then what does the DNA got to do with this? What was the murder weapon? You're gonna tell me you don't know?" Now, granted, it could be that it was just so brutal that you couldn't tell. But again, I mean, this is part of, and this is why I like all of us talking about it, because the fact of the matter is that it seems like a lot of people don't want to hear from people that aren't experts. But the truth is that, and I've said this a million times, is that the people that are going to decide, actually decide whether Bryan Kohberger is guilty or not, is regular ass people, not experts. People just like us. And I've said this, that no matter what side I was on, if I was on either side, I'd be trolling conversations just like this to see exactly what it is that I need to either play more to at trial if I am the defense, or what holes and gaps and parts of my case that I need to beef up for normal ass people. It's funny because somebody said the other day, they were like, I just don't know, like, why you're even wasting your time. This is a waste of time." And I'm like, "No, it's not really a waste of time. Not for me, it isn't. I've learned a lot of stuff doing this stuff, and not just from listening to like one expert, okay? Like, looking up people that have nothing to do with this specific case, and they're not giving me opinions based on their emotional, uh, subjective opinion of what's going on here and whatever their network is paying them to say. Because at this point, I express my sadness like every day about the fact that I'm just disgusted with this epiphany. This, I hate to say, but like this fake news epiphany that I just came to this year. I'm like super grossed out. But at this point now, I'm like, well, I always knew that like in a trial, you have you have different experts that essentially are going to say whatever it is that's going to add credibility or validate whatever it is that the side that's paying them wants them to say. You will literally have, there's going to be points where you'll have two experts that are looking at the same report. Not, we went and did our report, you went and did your report. We got two different reports that are saying two different things, and this is how we're interpreting them. Some of them is going to have, they're gonna be looking at the same exact report, and you're gonna have 2 experts that are gonna be telling you 2 different things about what the same exact words on that piece of paper say, and how you should interpret them as a juror. So, my thing is I'm not an alibi expert. I'm not a DNA expert. I'm not a cell phone data expert. I'm not a ping expert. I'm not a car identification expert. But I am doing a lot of research on all of that stuff so that I can educate myself on it, so that I'm not just at the mercy of whatever it is that Joe Blow and Annie Blow, that are experts for the defense and prosecution, are going to tell me that they mean. I'm going to know if I'm listening to one tell me something, right? This is all how we're, like, persuaded. What about the grand jury selection? It's kinda like doctors. 2 different doctors may treat the same condition differently. That is 100% true. I can tell you, so, like, with my job, okay? I have and it really, really upsets me to the sense that, like, I'm like, "You're really inconsiderate as fuck." Okay? In my job, we will have patients who, like, get into a car accident or slip and fall somewhere, right? And they, like, go to the emergency room and they have a scan done and they find that all of a sudden, after however many years of life they've been fine and they have felt fine, all of a sudden they have, like, this huge brain tumor that needs to be removed, okay? And to them, they'll read the report and they'll talk to the doctor, and the doctor will be like, "Okay, it's this 4 centimeter mass on such and such a place, and it can affect this and that, but it needs to be removed because it's just going to keep growing," right? And they're panicking, like 3 or 4 centimeters, and you're like, "Holy shit!" Like even if it was 1 centimeter, it's like there's something in my brain that doesn't belong there, right? And then they come to like see our doctors, and our doctors will be like, and this really just depends on what it is. Some, it doesn't matter if they're small or not. But some of them will come to us and the doctor will say, "Yeah, but I mean, I would never operate on that. Like, we would never operate on that until it was at least 7 centimeters." Right? So we're just going to we'll see you like every 6 months or every year and we'll keep doing uh, CT scans and whatever else we need to do. And we'll just monitor it. If it gets bigger, then we'll take it out. And these people are like, "What do you mean it's like not that big? Or what do you mean that it has to stay, like, in my brain until it's big? Can't we just take it out now?" And it's about perception, right? They may go to another neurosurgeon and they'll look at their scans and say, "Yeah, we could do surgery." And they do. And they, like, have to have another surgery right when they start having grandkids. And now they're in worse shape physically to handle a surgery like that. And you got a mess of other issues that you have to worry about that could potentially happen if they're gonna resect it. So, it's like when a juror's sitting there and they're listening to these experts, whatever they know, like, going into it, not to say that they have to be, like, highly educated on each of these. You don't need to be, like, uh, an almost member of the cast, the FBI cast team, you know? But whatever little bit of information that you go into is gonna change how you make your decisions or how you perceive the expert's testimony. It's crazy to me. I was trying to think of what else we were talking about today. I think we've had enough. My fingers are getting cold. I need to, like, crawl into bed. You guys are awesome for having me. That was so rough. I was about to throw my whole computer out the window. What a nightmare. I have no idea what some of these mean, what some of you are saying. I wish I did. Thank you. You're awesome too. You know that I know that, or I think that, I guess. Oh, there was one. Okay, before I go, perception is everything. This is why. Okay, so like you all don't have to believe your eyes are gray too, Caroline. Me and Bubby's are both gray, except my hair's like black and Bubby's is like brown. It's getting darker the older he gets. Actually, his are really interesting. His eyes, like a lot of the times, half of his eye will be like gray and the other half will be like blue green. It really just a bit depends on what we're wearing. Mine is usually gray though. But before we go, oh, perception is everything. That was what I meant to touch on is that you all don't have to believe everything that I say. Like I'm trying to gather research for y'all and like I've been around and talked to enough people to know that some of us, for instance, me, for example, I understand things better when I read it out loud. I know some people who will look at these court documents, they have no clue what they said. They could read it 300 times, but they have no clue until somebody else says it to them. And it's not dye, but it's also not black. It's just like almost black. It's very dark. My I'm getting off track again. My whole family, except for my mother and my brother, have black hair or very, 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 very dark brown hair and brown eyes. And my mother and my brother have blonde hair, like dirty blonde hair and green eyes. And my dad has black hair and brown eyes also. Somehow I made it out with very, 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 very dark brown slash almost black hair and gray eyes. Sometimes they're green though, but sometimes they're blue. They're usually gray. But anyway, I just want everybody to learn, I guess, and I want everybody to think for themselves. I realized after I had my fake news epiphany what actually was going on, and it made me physically ill. And so I'm just trying to encourage everybody to think for themselves and have damn, I can't even have this chat because I'm like I get so distracted. um, but everybody think for themselves and have conversations where we're critically thinking and not just relying on what we're hearing on the news. That is like the worst thing that could literally happen. I don't want that. And this is coming from somebody who was creating these documents and only wanting to put in the documents information that was coming from the police or actual uh news articles, right? Like I'm like I'm not going to put anything on there that I'm seeing like on Facebook. It's not verified stuff, and especially not if I can't verify it myself. But I always thought that like reporters and whatnot was going a step further and verifying stuff. And there are some I talked to a couple of when I say a couple, I can count on one hand that I talk to that do try really hard almost all the time to verify what they're saying. Um, but here lately, this shit with this case has gotten so out of control, and it makes me so sick when it's like we have to hear in the media or from the media when they're saying anybody that's going against like what we're saying here or trying to tell you that Bryan Kohberger is innocent or that the case is not strong, they're just they've got ulterior motives. Mm, no, I put up with a lot of shit here and on Twitter, wherever I am. Basically, if I'm anywhere, if I'm anywhere posting my opinion or talking or I'm on camera, there's some asshole who's screenshotting or screen recording or in my threads on Twitter telling me how dumb my opinion is and shit like that, and I do it all for free. And I could. I got like 7,000 people here, like, on my channel, um, and you guys, you put up with a lot, and I'm not even good, but I could turn on monetization for sure. I was eligible for that ages ago, but I don't do it. I do it for free because I want my opinion to stay based on what I actually feel. I don't wanna have to, like, change it to what everybody that's listening to me wants it to be. Does that make any sense? As soon as I start getting paid, I have to start saying what the majority of the people want me to say. I'm not gonna do that to myself. But before you guys go, this is super quick. For anybody that doesn't know who Bob Motta is, listen, he is a lawyer. He his father, which I didn't know this until, like, after I started listening to his podcast, but his father was the defense attorney for John Wayne Gacy, which I thought was cool as hell. Like, I guess the whole reason that he started his, podcast was because his dad had all of these, like, recordings of John Wayne Gacy for forever and ever, for years and years and years and years and years, and Bob has had them for years and years and years. And he waited a long, long time, before he did, but he finally decided to, like, start releasing them, and he started releasing them on the podcast, and the whole purpose is for education, right? Which I love. So, and he's really easy to listen to because I'm super particular about about podcasts if I can't see something on the screen, but he's funny as shit. But actually his podcast's a little bit different, but I'm gonna show you. I don't know if anybody's seen this, and I hope he doesn't get mad. I did send him a message, like, an hour ago. Uh, find him. Hold on. Publicly Buzzed. I think he's from West Virginia too. He had Bob on the other day. Wait a minute. And I was, like, busting out laughing. JB gets me like that too, where I'll be, like, driving on my car, and I put it on the little thing that's on my dashboard so that I could just, "Oh, Publicly Buzz is here. Did you get my thing? Like, can I play your I can show anything you want. Thank you." Um, and I was just like, I was watching, I felt, like, compelled to send him a message, and I was like, I've got tears in my eyes and some of the stuff that comes out of his mouth, but I'm gonna show you guys this, and I he was talking about, the probable cause affidavit, and I'm gonna talk to him because, again, I don't, like, know all of the rules. There's a podcast episode that was really super interesting about all of this, and I felt I tweeted it out, and I told everybody to listen to it, but I don't feel like everybody did, and so, Irina today was like, I had listened to it, and it was, like, really good, and he was saying A, B, and C, and it made perfect sense after I heard him say it, and I was like, "I wonder if he'll, like, let us stream that?" I don't really know. I mean, I can tell you to go to the podcast, but that doesn't mean that you're going to. Thank you, sir. My mic sounds fantastic. Whenever, like, it's working. I don't know if you rewound. If you rewound, you're gonna wanna, like, fast forward quite a lot. We had some major issues. I need, like, a I can't pay you because 'cause I'm not paid. I mean, I'm paid for my real job, but not this one. But I spend, obviously, all of my time researching this other stuff and not enough time researching, like, how to make this screen sharing and whatnot work well and smoothly. It worked the very first time I did it. After that, fucking forget it. Alright, let's pull up Publicly Buzzed. I think he, like, clipped it, so it was a shorter one. I'll watch you guys, and you're obviously gonna wanna go listen to the entire thing, but the clip will reel you in for sure. If you have if I guess if you have a where is it? Oh, here. If you have a sense of humor like me, I'm gonna play this, and then I'll just watch you all. Like if you guys want to just watch it elsewhere, like go over to his page and watch the full thing instead of the clip, then we'll just cut it off. But I like to share with you guys. So let's see. I wonder if I'm gonna be able to mute my mic because I'm telling you, I was literally in tears. I will blow your eardrums out. All right, present. There they are. All right. So this is publicly buzzed. I'll put the link down here. I'll put it for I'm gonna have him well, I'm sure I could tell, but I'll put the full one in there, not just this clip one. All right, so they're talking about the probable cause affidavit for this case. I'm gonna mute myself and make sure. Let me know that the sound is coming through for the video.
Yeah, so we're going to dive into a little bit of this Idaho stuff here tonight. Everything has been hot as fuck this week with the grand jury. And yeah, me and Dan have got a lot of actual questions. Today I was going back over the affidavit, some of that stuff. And yeah, just in general, I know that when you were on Jay's show, you were saying, and a lot of different opinions on this, however you want to look at it, but you think that the affidavit is strong.
I do. Well, like if you compare PCA in Idaho 4 to say Delphi, can you put those two on next to each other? You can see what an incredibly weak PCA is, which is Delphi.
Right.
And you can see what a strong one is with respect to, the Idaho 4 case, but then on that side pod that I'm talking about, the docket, like I go through, like I have 4 episodes on, Idaho 4, like one is in the can that's getting produced now that Alice and I just recorded. And it was after the arraignment when he stood silent, which like the whole internet exploded. I'm like, dude, it doesn't mean shit. It's got no legal consequence. It's like the judge entered what he would have said anyway, which is not guilty. And like we were trying to come up with, without being in Ann Taylor's mind. We'll get into that. I'm sure you guys have questions.
That is actually where that was one of them for sure.
Yeah, well, like I'll wait on that. But in terms of that PCA, when I start digging into it, then you start to see all the warts. And I'm talking about the Idaho 4. Like the whole thing with Dylan stinks. Like there's something off about that. Like, like this frozen shock phase bullshit doesn't make any fucking sense. This is clearly a kid who's like in college. Everyone rages in college till 4 in the fucking morning. That's not unusual. You have Xana ordering fucking DoorDash at 4:30 in the morning. Yeah, I mean, that's college. That's what it's like. I mean, like this isn't normal adult world where, we're all in bed by like 1 at the latest.
Yeah.
Some people were in bed by, they raged all night. They went to the bars. They came home at 2:30, fucking around. Like even her seeing somebody walking out of that place, she would have assumed, I think, that somebody in the house hooked up.
That's
and
what
that
I would think. Yeah.
was shedding. You know what I'm saying? Because it's like she had no reason to believe, because no one would in that position, that 4 of her roommates had just been murdered. No one is ever fucking thinking that. And she clearly didn't hear any screaming. If she had heard screaming, it would have been in the PCA. So the PCA, like what's silent in the PCA is the shit that tells you what didn't happen.
Right.
Because she had heard people screaming, that 100% would have been in there. If she had heard people screaming, she would have called 911. The fact that she didn't call 911, well, and when you look at it and you're trying to figure out, okay, well, what are the cops trying to accomplish here? And I heard that both Steve and Dan, I heard you guys talking about the concept of cops leading them down the primrose path, which happens all the time. Like exactly what you're saying, where like Dylan is like explaining something, and then the cop suggests, like, well,
yeah.
Well,
they're putting words in her mouth. Yeah.
Shock. Like you were in shock, right? And she's like, yeah, okay.
Yeah, that
you
works.
know what I mean?
Right. She's probably actually at that moment, she's actually seen some shit, right? She's woke up, seen the house.
At this point, she's traumatized.
At that moment, right? She is in shock.
Yeah.
So, but at 4:30 in the morning, she just thinks her roommates are being assholes and they're like fucking with her ability to be able to fall asleep. She's probably, she hears the dog barking upstairs and she's like, shut the fucking dog up.
Yeah. She's trying to go to bed.
Right, like Xana and Ethan.
That one, shut the fucking dog up, had me in literal tears. He's so stupid. He's like nerdy whenever he says something. I'm just like, what a jackass. Like, it's just, it can be funny that way. But I agree with him. We've talked about this. I don't think she was scared. And also the affidavit didn't say that she was scared. He just said she was frozen.
Her arguing is what she thinks in her mind, you know, and then she peeks out a few times. She sees some dude leaving. She doesn't see him covered in blood because it's fucking dark. The guy's wearing all black. If he's got a knife, which he had to have because he had to get it out somehow, we know he left the sheath, so it's not in the sheath, so he has to be carrying it by his side, or he tucked it inside of a jacket pocket somewhere.
Yeah.
But she's not seeing that either, so she has no reason to think anything has gone on nefarious. So she just goes to bed. Like, that's why she doesn't call. But Moscow police, they don't call until 11:48 or 58, whatever it is, the next day, right before noon. They have to come up with an excuse. Like, why the fuck wasn't law enforcement called until noon?
Yeah, dude.
When you have 2 surviving people in the house, it makes no sense. You know, so like that was the shit they were trying to deal with, is all this shit was coming down because the whole world was blowing up on this thing. I'm like, man, just, you know, when I started digging into that PCA, it became less strong than at first blush, you know, but like, that's what I do for a living. I read PCAs all the time when they come. My job is to pick them apart, you know, because we have no idea. Like, all we know about that DNA on the sheath is claiming it was single source, right? We have no idea what the quality of the DNA, like, we don't know if they're going to get a partial profile or a full profile. We don't know any of that. And anybody who's acting like they do know is full of shit, because we don't know. I deal with DNA in my cases, and I know what a good profile looks like, and I know what a shit profile looks like. And if it's like a partial profile, it's not going to be that great of evidence in terms of, look, you know, like, this is a bulletproof. The guy has his fucking DNA on this sheath. Now explain why it's in here.
Well, actually, I have a question. I have a question about that. So, could they determine, after analyzing the father's DNA, could they determine 99.999% on a partial sample from the sheath?
I mean, maybe. Like, as to dad, but like, dad's irrelevant now. Like, the internet was blowing up, and people were like messaging me and like, oh, is the sheath going to be, because like, if you look at one of their state's responses for the discovery, like the motion to compel from the defense, where they're saying turn shit over, you owe us shit. We know this shit exists and we want it. And one of the things they've been asking for is the genealogical DNA like tests. They just want to see all the data. They want to see the research that was done, so that they have it. And I think that they have a right. I think ultimately the judge is going to rule that they have to turn it over, because the state is like, look, it's like, number one, we're not using that DNA because we now have the defendant's DNA. That's what we'll use. That'll be the profile that we're comparing. Dad's is never coming into trial. We have no intent on using that. So people were confusing that as saying that, oh, well, now they're not going to introduce the sheath. I'm like, what the fuck?
I just want to cut in because I think he says this. Maybe he says it in the bigger one, but there was a really good point that got brought up about this um, partial print or partial profile, um, and whether it was going to be good enough, yada yada. And one of the things that got brought up was, if it was, let's say it was a full profile, but was only in a little bit of an amount, and it went to, like, you know, person A, lab B, lab C, they kept using it. If it got to the point where, once the defense is like, we want our experts to run their own tests on that DNA sample, there better be some left, because it's not going to look good if it's all gone. And they're like, well, now you can't test it for yourself. You can only look at our reports and see if it says anything different than what we're saying that it says. You know what I mean? Yes, Megs. I know. Remember, I said that I had asked him about it. Even if they find out that the sheath, the knife that fits in that sheath, is not consistent with the murder weapon, it's still coming in. it'll just be up to the jury to determine via 2 different experts whether or not it has any relevance. All right. We're almost done.
Fuck are you talking about? It's the strongest piece of evidence they have. Of course they're introducing the sheath. Now, if they're like, the sheath is one thing, because the sheath was found pursuant to a search, whether it was warrantless at first, which is there's a carved out exception for it, because there was a homicide that took place. So the cops, when they walk in a homicide scene, there's an exception to the warrant where they can search the house. Number one, they're going to clear the house. Number two, then they're going to conduct a search, but then they're going to send somebody over to the courthouse to go get the warrant, which they did. So they covered their ass every way that they could with that. So the sheath is getting in. The question is whether or not they're going to turn over those reports. And if they continue to refuse to do it, the judge might bar them from putting any DNA evidence in, which will force them to cave, give the defense whatever the fuck they want with it, because the defense deserves to have it all so that they can send it to their expert so they can compare. Because there is a chain of custody issue, at least as to the DNA that came from dad. Like the sheath never went anywhere other than Idaho,
The third party.
police, and then sending it to the lab, and then it gets sent back to Idaho. Like the garbage from, you know, the house in PA, that went from PA to a lab to Idaho, or from PA to Idaho to a lab. You know what I'm saying? And like anytime you have evidence and anytime it starts moving into different hands, that's where you worry about the chain of custody. For us, for defense attorneys, chain of custody is everything. That's how I know that they're not fucking tampering with the evidence.
Yeah.
You know what I mean? Like that's huge for us, because that concept that, you know, the police never cheat is of course ridiculous. I mean, they do. I mean, like the cops aren't out there trying to like plant shit on innocent people. What they do is they plant shit on people that they think did it, and they don't have the evidence to get them. Like
Right.
that's
100%. So people get confused and they try to say that I feel like he absolutely didn't do it. There's no way in hell that Bryan Kohberger did this. What I'm saying is that my questions come from exactly what he just said. Is that, and someone actually said it on in one of my comments, is that police don't set people up, right? But they do find evidence based on the person that they think did it. And for anybody that doesn't know, I'm not just saying that because I don't like the police or anything like that. My uncle, Joe, was a cop in Center City, Philadelphia for 25 years before he retired. And he's a badass motherfucker. And he's very fair and kind and strong. And he doesn't take any shit. And he'll be the first person to tell you that shit like that does happen all the time. Police are normal people. There's good people, there's bad people. Police are people.
happens. You know,
That's
it's like
scary as fuck.
it's scary as fuck, right? So
Before
you
hang
know,
on, before we move on, I got a legal question, Bob, about the father's DNA comparison thing. So because that was actually used in the probable cause affidavit, would that then be required to be handed over to the defense because it was in the PCA?
That's what the defense is saying. And then when the state replied in their response, which, you know, I've obviously read at this point ad nauseum, the state is saying, look, pursuant to 16.1 of the IRC, which is the, you know, Idaho Rules of Criminal Law, that they don't have to turn it over because that DNA did not belong to the defendant. It's not relevant to the case. We're not using it. That's so when we have that hearing on the 9th of June, Dan, it's going to be all about that. Like that is what that battle is going to be about, whether or not they have to turn it over. But what I'm telling you, it really is irrelevant in terms of the case because they have DNA of the defendant. You know what I'm saying? Like the old man's DNA is irrelevant. What they're going to have is a profile that they've created from the defendant's DNA because he was compelled to give it over. So they went and created the DNA from that. And then they have the profile that they've got from the sheath. So you got the sheath and then you've got his. And that's what the comparison is. The old man shit is irrelevant. It really is. It doesn't matter at all. But point is that the defense deserves to be able to see that report that was generated off that DNA that was found there just to see how they got to it. You know what I'm saying? Like for comparison's sake, they're going to want to be able to turn that over to their expert to look at it. Like,
Does it
you know,
does it feel like there is some shady shit going on to you from looking at it? Like,
no, I mean, dude, it's
is
like
it just kind of how the game's played? Like,
I know how the game's played, dude. Like if you ever get to my Garcia season, that was a fucking war. That was a fucking war. I mean, Allison got kicked off that case for making doing a Skype interview with the news because they hated my wife because she's a fucking pit bull. She was literally papering them to death with her motion work was unbelievable. She was fucking like, they were like, dude, we got to get rid of this bitch because she is a fucking animal. You know, like for real though. And it was like, and that was a war. They did, you know, it's like a case like that, the state has spent so much money, so much manpower, so much time, and they have so much invested in this guy being the guy. They're going to do everything in their power to get that conviction. And, you know, and if you've got a strong defense attorney on the other side, you're going to fight like hell.
Riverside is the leading platform.
So hopefully you like that. He's so funny. He's super smart. I was so tickled to see him on there. 100%. CH said, amazing they can get DNA returned 2,500 miles away in 24 hours, but they can't get discovery to the defense in months. I was listening to somebody's live earlier, and there was a person that was on there, and they were discussing the different filings and stuff. And like my eye was twitching because I'm like, no, 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 no. Please, no. This is just adding to confusion. That is not what it says. That is, you know, and I think that everybody comes from a place of wanting to help everyone understand. I truly do. Well, most people, right? But when it comes to the filings and stuff, I actually was floating this idea to somebody. Would it be helpful if we had like one day where no, it's not. Twitching eyes are never good. Not for nothing, but I look crazy. And secondly, then it makes my eye water. And then we got issues because of my lashes. So it's just all around. I just don't like it. So I clicked out of it. But would it be helpful if we did like, and I could prepare it all, maybe even in a slide, which probably won't fucking work, but prepare it in a slide to where we can go through like each of the filings, like in chronological order, and what they say and what they don't say. So like when we're talking about, for instance, just because somebody did just bring it up, and they were talking about this earlier, the motion to compel, right? Which I think was seemingly Ann Taylor's final straw because now she's going pretty hard. But would it be helpful to go through those things? Like for instance, say, okay, so on this day, the defense filed this supplemental request for discovery. We don't know what it said, but we know that they were asking for something. And then on this day, they put in a second supplemental request for discovery. And we also don't know what that was because it's sealed. But then on this day, they put in a third supplemental request for discovery. This time they requested it not be filed under seal. So now the whole world can see what it is. And they're asking about this genealogical DNA and they want A, B, and C, and they want to look at this and that. And that you haven't provided certain things like body cam footage of the arrest and shit like that, right? Things that you absolutely should have. 1,000%. You should already have that. And he wasn't asking for anything that like wasn't, and there was one about an interrogation between he and Brett Payne. And this person that was talking about it was like, well, then the prosecution filed a filing saying that they didn't have or said that they had already provided all of that, which is also happens to be like the narrative that was going around in the news. Just because they're asking for it doesn't mean that it exists. And I was like, well, that's bullshit because I bet you it exists 100%. And I don't think she'd be filing a motion to compel over something that probably doesn't exist, because now she's got to go to court. She's got to argue why she knows it exists. I think she's been very consistent in all of these filings about exactly what it is that she's asking for. And she's always said, for instance, when she says that there's exculpatory information, it never says there may be, or she thinks that it's exculpatory or this or that. She says that, let's say, Bethany has exculpatory information that only she knows, that only she can testify to. And then in today's filing, that they've been given because they've been given extensive discovery from the prosecution, they know that exculpatory evidence exists. And I think where people get all upset and, oh, absolutely not, she's lying, she's just saying that because she knows that we're watching, right? I think that when they do that, they think that one tiny piece of exculpatory evidence means that this person is innocent and they're going to be set free. And that's not the case. Exculpatory evidence can be a ton of different things. But if you have like a lot of exculpatory, for instance, let's say that I'm right about the car passing like the 3 times or whatever, and that it would have had to have originated in behind the house because of how many, the 3 times that it passed. Hey, Tyler. Because of the 3 times that it passed, if that's the case, and at the same time, you've got somebody that was over in Pullman and you're saying that he was on camera, and this is just a for instance, and he's on camera over there, well, that would mean, and his phone's pinging over there in Pullman, that would mean that he wasn't sitting behind the house and his car didn't originate from back there, right? So that in itself would be exculpatory if you're saying that the car that was carrying the killer was seen passing 3 times and then leaving via Walenta Drive starting at 3:29, and you've said that Bryan Kohberger in his car and his phone is pinging in Pullman, then that couldn't have been him, and that is exculpatory. Now, I don't know that that's enough to, I'm sure it could be explained away that it was a different car and they were never saying that it was this or that and whatever, whatever the case may be. But there's all different kinds of exculpatory information. We know there's likely something that is exculpatory because we have this Brady Giglio thing going on. But anyway, I don't remember what I said, but I did see a lot of people say that they thought that that would be helpful. I don't want to like do anything that's not going to be helpful, but it just seemed, as I was listening to it, it seemed like people really wanted to know that information and understand it and have it put in, like I said, chronological order so it makes a little bit more sense. So in that particular instance, what it was the prosecution did file something and they did say that we did give you everything. But then they also said some of it you don't get to see and some of it we don't even have yet. So we gave you everything. If we didn't give it to you, we either don't have it yet or you don't need it because it's not material to your defense, which is just absurd because how the fuck would you know? So I think having made that clear and the fact that they are still doing their motion to compel, which I believe it was supposed to happen the other day when they had those other hearings, but got pushed back. So we still haven't even had that yet. But they wouldn't be having it if the if the judge looked at it, it was like, no, you don't get this stuff. I don't know. I like talking to you all. Yeah, this was really gross. I mean, it, and then somebody, if I'm not mistaken, somebody commented on it and was like, "That's disgusting," or something to that effect. And he was like, he made a comment about being sick because you're commenting on a dead girl's and these are his words, like something like a dead girl's pictures or something. And I just thought, deflection? I mean, I'm sorry. Like, I understand that his on again, off again girlfriend was slaughtered in like the most horrific way. But still, yet you shouldn't be talking to people. I'm shocked that Steve didn't see that and was like, "You let him talk to you like that? Really?" I don't know, man. Whatever. I know exactly what the fuck I would say if someone said that to me. Disgusting. But hopefully, I'll get through that little blip we had in the beginning when I tried to play that thing. I'm gonna try to post it as like a video so we don't have all the extra bullshit. But thanks for being here. I'm gonna go to bed. It's 11:52. It just turned 11:52 here. Don't be mean in the chat. It doesn't matter because we're leaving. But thank you all for being here. I love you all. Have a good night.